There's a knock at your door. You look through the window. Men in tactical gear. Badges that say ICE. Your heart stops. What you say in the next 30 seconds determines whether they walk away or walk in. Every day across America, people open their doors, answer questions, and hand over consent they didn't know they were giving. They think cooperation protects them. It doesn't. The Constitution protects them, but only if they use it. I've analyzed hundreds of immigration enforcement cases. You studied the controlling Supreme Court rulings and reviewed the actual training documents ICE gives its own officers. And what I found will shock you. Because ICE's own internal training materials, the documents they give to their agents, admit exactly what your rights are and exactly what they cannot do without your permission. There are 4 words that, spoken clearly through a closed door, legally force ICE agents to either produce a judge-signed warrant or leave your property. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Most people have never heard them, and that ignorance is exactly what enforcement operations count on. This is educational content only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Now let's break down the 4 critical mistakes people make and the exact words that protect them. Mistake 1. Opening the door, the mistake. Agents knock, you open the door. You think you're being cooperative. You think you haven't done anything wrong. You think opening up shows you have nothing to hide? You just made the most expensive decision of the encounter before a single word was spoken. The scenario, it's 7 a.m. There's a hard knock. You open the door and 2 ICE agents are standing there. One holds up a document. "We have a warrant," he says. You step back instinctively, giving them room. They walk in. That's it. The encounter is over before it started. Not because they had legal authority to enter, but because you opened the door and stepped back, and a court will later call that consent. Why people do it? People open doors because it feels rude not to. Because they assume legal authority means they have no choice. Because in the moment, with uniformed officers on your step, your instinct is to comply. But here is the legal reality. In Payton versus New York, decide where you feel you have no choice but to open the door. They knock loudly, they announce authority, they hold up documents. The psychological pressure is designed to override your legal instincts. It works on almost everyone. The correct move. Do not open the door. You can speak through it. You can speak through a window. You are under no legal obligation to open your door to allow a visual inspection, to accept documents by hand, or to give agents physical access to your threshold. Here are the 4 words. Say them clearly, calmly, through the closed door. Do you have a judicial warrant? That's it. That is the question that changes everything. Not, do you have a warrant, because they will say yes and hold up an administrative form. You must say the word judicial, because that one word is the legal distinction that controls everything that happens next. Why it works. ICE carries 2 types of documents they call warrants. Form I-200 is an administrative arrest warrant. Form I-205 is an administrative removal warrant. Both are signed by ICE supervisors, not judges. Neither is reviewed by any independent court. And ICE's own training materials, obtained through Federal Freedom of Information Act litigation by the Immigrant Defense Project, explicitly state that administrative warrants do not authorize entry into a home without consent. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. And when you ask for a judicial warrant, one signed by a federal judge bearing a court's name at the top, with a case number, you are asking for something ICE almost never has for a residential arrest. Federal Law Enforcement Training Center instructors have said on record that when an ICE officer has only an administrative removal warrant and no consent, that officer has no legal authority to enter the home and must wait outside. Bottom line, never open your door. Ask for a judicial warrant first. Those 4 words, do you have a judicial warrant? Immediately identify what authority is actually at your door. Mistake 2. Answering questions about who is inside. The mistake. You don't open the door. Good. But then the agent asks, is name home? Or how many people live here? Or are you a citizen? And you answer. Maybe you're nervous. Maybe you think answering a simple question is harmless. You just became a witness against yourself and potentially against everyone in your household. The scenario: you're standing at your closed door. The agent outside says, "Ma'am, we're just looking for someone. Is there an adult male at this address?" You say, "My husband is here, but he's sleeping." The agent says, "Could you ask him to come to the door?" You just confirmed the location of the person they're looking for. You did their investigation for them in 30 seconds. Why people do it? People answer because the question sounds innocent. Because it feels like refusing to answer a simple question is suspicious. Because the social pressure of uniformed officers at your door is enormous. But officers asking questions through your door is a voluntary encounter. You are not detained. You are not under arrest. You are standing in your own home. The Fifth Amendment protects your right to remain silent. And unlike in the traffic stop context most people are familiar with, you don't even need to open your door to invoke it. Legal reality: the Supreme Court in Salinas versus Texas, decided in 2013, established that you must explicitly invoke Fifth Amendment protection. Silence alone is not enough. You have to say the words. But here is what is different in the home context from the street context. You are behind a closed door. You can speak the invocation without any physical exposure at all. Evidence problem: anything you say through that door can be used. If you confirm who is inside, where they are, what room they're in, whether they're awake, every word of that becomes investigative information that agents can use to build their case, document in their reports, and reference later in removal proceedings. The correct move: after asking for a judicial warrant, if the agent continues to ask questions, you say, And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. I am invoking my right to remain silent. Say it once, clearly, then stop talking. You do not need to explain why. You do not need to apologize. You do not need to engage further. The invocation is complete. Anything asked after that, you do not answer. Why it works: this explicitly invokes your Fifth Amendment protection under Salinas versus Texas. Your silence now has legal cover. It cannot be used as evidence of guilt. The encounter from this point has hit a constitutional wall. The agent has no consent to enter, no answers to build on, and no lawful path forward without a judicial warrant. Mistake 3. Taking documents at the door. The mistake. The agent says, "We have a warrant. Open the door to receive it." Or he slides something through your mail slot and you pick it up. You read it. It says, "Warrant" at the top in bold letters. It has an official seal. You think they have a warrant. I have to let them in. You just confused two completely different legal documents. The scenario: you ask for a judicial warrant through the door. The agent holds a paper up to your window. It says "Warrant of Removal/Deportation" at the top. It has a DHS seal. A name is on it. You think it looks official. You open the door. That paper is Form Y205. It was signed by an ICE field office supervisor. No judge reviewed it. No court issued it. It is an internal agency document authorizing the agency to remove someone, not a judicial authorization to enter your home. Why people do it? Because the document looks official. Because it says the word warrant. Because without knowing the specific legal distinction, there is no way to tell from appearances alone. Legal reality. Here is how you tell the difference. A judicial warrant will have the name of a federal court at the top. For example, United States District Court. It will have a case number. It will bear a judge's signature or a magistrate's signature. An administrative ICE warrant will say Department of Homeland Security at the top. The difference is visible. You have the right to ask them to hold it to the window or slide it under the door, so you can read it before deciding anything. Courts, including a federal district court in California in 2024, have ruled that administrative warrants do not authorize ICE to enter homes without consent. That ruling is binding in the Central District of California and signals how other jurisdictions are reading the Fourth Amendment. The correct move. I ask them to slide the warrant under the door or hold it to a window. Do not open the door to receive it. Once you have it, look at the top. If it says DHS and has no court name, no case number, no judge's signature, you are looking at an administrative document. Speak through the door. This is not a judicial warrant. I do not consent to entry. Say it calmly. Say it clearly. Say it firmly. Why it works. You have now named the document correctly on the record. If there is any recording of this encounter, body camera footage, your own phone, you have stated clearly that you identified the document type and explicitly denied consent. You haven't interfered with law enforcement. You haven't obstructed anything. You have exercised a constitutional right that the Fourth Amendment places at the entrance to every home in this country. Bottom line, know the difference between a judicial warrant and an administrative one. The word warrant on a DHS form does not give ICE authority to enter your home. Mistake 4. Physically interfering or opening the door in a confrontation. The mistake. The agent gets frustrated. He raises his voice. He says you're making this hard. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Harder than it needs to be. He says he'll be back with more agents. He says you're obstructing. You feel the pressure escalate, and you either open the door to de-escalate, or you do something physical to block entry. Both of those responses destroy your legal position. The scenario. You've said all the right things. Closed door. Asked for a judicial warrant. Invoked your right to remain silent. Identified the document as administrative. Denied consent. Now the agent is angry. He says, you're going to regret this. He calls for backup. You panic and open the door to talk it out. That's consent, again. Or you physically push back against an agent who forces entry. Now you potentially face obstruction or assault charges entirely separate from any immigration matter. Why people do it? Because sustained confrontational pressure in front of your own home is terrifying. Because the instinct to de-escalate physically is powerful. Because you don't know if staying inside and repeating your rights will actually work. Legal reality. You have the right to deny entry. You do not have the right to physically interfere with a lawful arrest that occurs outside your home, or with agents who may forcibly enter in jurisdictions where courts have not yet ruled on the administrative warrant question. As of early 2026, this legal question is genuinely contested. A federal court in California and a federal court in Minnesota have ruled that warrantless home entry by ICE violates the Fourth Amendment. A federal court in Texas has reached a different conclusion. The Supreme Court has not yet issued a definitive ruling on whether administrative warrants satisfy the Fourth Amendment for home entry. This is an actively evolving legal landscape. What this means practically is that if agents force entry anyway, your job is to not escalate physically. You have already built a record. The denial of consent is on record. The request for a judicial warrant is on record. The identification of the administrative document is on record. That record is what your attorney will use later. Evidence problem. A physical confrontation wipes out everything you have legally built. It reframes the entire encounter away from Fourth Amendment violations and toward criminal conduct on your part. The body camera footage of you pushing an agent becomes the story, not the warrantless entry, the correct move. Stay calm. Stay behind the door if you haven't opened it. If agents have forced entry despite your refusal of consent, yet do not physically resist. State clearly for any recording, I do not consent, I am not resisting. Those 5 words spoken calmly are your record. They document that anything that follows is happening over your explicit objection without your consent and potentially in violation of the Fourth Amendment rights the Supreme Court established in Payton v. New York in 1980. Why it works. You are not obstructing, you are not resisting. You are creating a verbal record of a non-consensual entry. That record becomes the foundation of every legal challenge your attorney can raise afterward. Here is the truth about a knock from ICE. It is not a conversation. It is a legal encounter where every word, every opened door, every answered question, and every document you accept at the threshold determines what happens next. The law does not protect people who panic and open doors. It protects people who know exactly what to say and stay calm enough to say it. Let me give you the 4 responses one more time. Memorize them. Practice them. Say them until they feel like second nature. Response 1. Do you have a judicial warrant? Ask it before anything else through a closed door. Response 2. I am invoking my right to remain silent. Say it after the warrant question if questioning continues. Response 3. This is not a judicial warrant. I do not consent to entry. Say it after reviewing any document they present. Response 4. I do not consent. I am not resisting. Say it if entry is forced to preserve your legal record. Print these out. Put them somewhere in your home where every adult can find them quickly. Practice saying them until they feel automatic. Because when it's happening, your heart will be racing, your hands will be shaking, and you will not have time to think. One final note that is important. This area of law is genuinely unsettled as of 2026. An internal ICE memo from May 2025 instructs agents that administrative warrants may be sufficient for home entry for people with final removal orders. Federal courts in California and Minnesota have rejected that position. Federal courts in other jurisdictions have not yet ruled definitively. The Supreme Court has not resolved this conflict. What that means is this. The constitutional arguments for your protection are strong, established, and supported by decades of Fourth Amendment precedent, including Payton versus New York. But the legal fight is ongoing, which is exactly why documenting every encounter, exactly what was asked, exactly what you said, exactly what document was presented, matters so much. That documentation is what allows courts to do their job. This is educational content only. It is not legal advice. For your specific situation, consult a qualified immigration attorney in your state. If this helped you understand your rights, hit that like button. Subscribe for more legal breakdowns. Share this with everyone you know. Family members, neighbors, anyone who needs to understand what the Constitution actually protects inside their own home. Because the smartest thing you can do is know exactly what. And if you liked the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell to say before you ever need to say it. Stay informed. Stay protected. Stay behind that closed door.